approval of the minutes from the December 13th, 2021 meeting. Is there a motion to approve?
Your Honor,
before we do that, before we do that, Attorney Del Campo, could you do the roll call?
Sure. Judge Avery Whetstone?
Here.
Judge Bellis?
Here.
Judge Cobb?
Here.
Judge Farley?
Here.
Judge Hernandez?
Here.
Judge Nguyen O'Dowd?
Here.
Judge Prats will not be here, and Judge Truglia will not be here unless they have come in. I don't hear them, so we're all set, Your Honor.
Thank you very much. Is there a motion to approve the minutes from the December 13th meeting?
So moved, Judge Bellis.
Thank you. Is there a second?
Second, Judge Cobb.
Thank you. Are there any changes or modifications to the minutes?
Your Honor, I have a clarification, if you don't mind. The last time, part of these minutes are the peremptory challenge, is the peremptory challenge rule that you are recommending for public hearing. What we noticed in putting the appendices together, and it was intentional, I suspect, but there's no number on this rule. And the question that I'm unclear about is whether or not you intended this to be a freestanding rule, which would be in the general section of the practice book, or do you intend to attach it to, one, the civil jury trial rule, and two, the criminal jury trial rule? Depending on that decision, it'll have a specific number, or it'll be two rules. And I will, if it's a single rule, I will have to make reference to the civil and the criminal rule somewhere in there. And if you just want to amend the criminal and the civil rules and have this rule, separate rule attached to those two chapters, then we can do that. I just wasn't sure. It's currently, it has no number. It can be discussed later even and figured out prior to. That was a little unclear.
Thank you. I certainly don't have any strong opinion on it. I have a slight preference for doing it in the general section, but my recommendation would be for maybe the CAJ civil and view of it. So the committee what they want to do. Open up the floor to suggestions. All right, I'm going to take this as acquiescence. Why don't we do that, Attorney Del Campo? Why don't you talk to CAJs of criminal and civil? They would be okay with general rule of the practice.
To do that, I just come back to you with the criminal and civil rights, that general rule. That the rule, and that's. Okay.
I'm sure you will surprised of that.
Okay.
Thank you. That understanding, is there all in favor of approving the minutes? Aye.
Aye. Aye.
Say no. All right. This is unanimously. Item out of order, nominate Judge Noble, who's as well. The fourth item, 2021. Or on the agenda to Form 206. Attorney Del Campo.
On the agenda last, unfortunately, but in putting the appendices together, we did notice slight inconsistency in language. I did Noble briefly. He is to present clarification of language. Your Honor.
Thank you to Carolina. Pick this up. We use reports. Request for production. Please copy of any reports referenced interrogatories for what was referenced 4 and 5 was not reports. So this is to reflect records. And then shield that interrogatory production number 10, which is invoice or report. Interrogatory number 4. Indicative of request for production number 1. Thanks to her great editing, I ask that the committee accept these changes.
Thank you. And heavily rely on staff to make sure that we get it perfect. So I appreciate it well. Well, let's just do this. Is there a motion to modify the proposal as reflected, Judge Noble?
Moved, Avery Whetstone.
Is there a second?
Second, Cobb.
Is there any discussion? Hearing none. All
Aye.
opposed? That passes. Thank you very much. You have a mediation. You have to take your time.
Welcome, everybody. Be safe.
Thank you.
We'll go back to our agenda now. It's the next item is 2020-014 proposal from Faiz, section 6 regarding materials, and have a memorandum our council. So I will, I guess, open it up, but I think the upshot of the proposal as characterized by our council is that we should be no action on this item. Is that his understanding, and is he okay with that outcome? Okay, so hearing nothing, is there a motion to table this item?
So moved, Judge Bellis.
Is there a second?
Second, Judge Cobb.
Thank you. Any discussion? All in favor of tabling this item, please say aye.
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 Opposed, say no. That passes unanimously. Next is 2021-011, reconsideration of a proposal based on additional comments received that had not been considered regarding Judge Conway's recommendation to modify several sections of the practice book dealing with delinquency cases. Attorney Del Campo?
Yes, this was, I think, on, you actually had recommended this for public hearing, I think in November, December. I came to you and indicated that the Chief State's Attorney had submitted comments that were not considered. We received them late, so you reconsidered this last meeting. What you have in your package now is another comments from Attorney Colangelo, as well as the child advocate, as well as or the victim advocate, and as well as a response to that from Judge Westbrook. I know Judge Westbrook is in attendance today, so she may wish to speak.
She is. She's on my screen.
I am.
So welcome, Judge Westbrook.
Thank you. I'm here, I guess, today to address any questions you might have. I did submit something in writing in response to the Chief State's Attorney as well as the victim advocate's concerns. But I'm here if you'd like to hear from me directly or to respond to any questions that you might have.
Are there any questions for Judge Westbrook regarding her response?
I just have a question. Judge Westbrook, could you have a chance to respond to Attorney Colangelo's December 23rd letter? It seemed to me that your response was to his first letter, not his second one. And then the second letter, he's talking about, he's criticizing the risk assessment tool that's being used, et cetera. I don't know if you saw that letter.
I've only received one letter. I'm not sure if a second letter was received.
Yeah.
It was dated December 23rd. It may not have gotten to you before your response.
I have not received a December 23rd letter.
All right. Why don't we pass this item for this month so that we can get those materials to Judge Westbrook so she can respond to that.
All right.
Is
Thank
there
you.
any to that? All right, thank you. Thank you, Judge Westbrook. Sorry to bother you.
No, thank you. I appreciate it. See you next month.
Okay. The next item is 2021-018, proposed revisions to practice book section 2-16 regarding attorneys appearing pro hac vice. Attorney Del Campo, this is on our agenda.
Yes, Your Honor, this has come up through court operations. The changes that are being requested are intended to comply with changes that have already been made to an appellate rule 62-8A. We have Attorney James O'Connor on the call from my office, who's looked at these changes to make certain that they were in compliance with or didn't conflict with the appellate rule. And if you have any questions, he is available for those.
Thank you, and welcome, Attorney O'Connor. Are there any questions for either attorneys Del Campo or O'Connor? Judge Bellis.
I should know the answer to this, but I don't. Do we generally incorporate the specific references to the actual form numbers in our rules? Is that what we do?
We do sometimes. We do actually. You know, it causes some trouble over the when the rules are amended or when the forms are amended, and we have to catch up with them. But in this case, I think it is not inappropriate. The one thing I will say is that there is a suggestion that we take out this language. Any such application shall be made on a form prescribed by the chief court administrator. Typically we don't take that language out because it's there. Judge Carroll actually does get the forms. If it says on a form prescribed by the chief court administrator, he or whoever is the chief court administrator actually gets the form and has to approve that. And for whatever reason, there's about a dozen forms that he does that for. It used to be approved by the entire bench. You remember you used to have volume 2 of the practice book in which you had forms and the whole bench would have to approve them. It's been boiled down to this. And sometimes it says office of the chief court administrator, which he has granted me the responsibility to approve those forms. So that's the whole other battery of forms that were approved that are referenced. But you can take that out. I don't have a reason necessarily for taking it out other than there are so many forms now cited in this rule that it appeared, at least to the proposer, that perhaps this language should come out, but I'm not sure of that, quite honestly.
I was just wondering if we're trending towards, just for consistency's sake, trending towards specifically referencing the actual form, because I just think, just for consistency, someone's looking at the practice book and we're referring specifically to a form here, but we're not specifically referring to a form number somewhere else. They might try to read something into it. I don't really I just want to be consistent. That's all. Doesn't really matter to me so much. I just wondered if that's what we're now trying to do.
No, not systemically. No, I mean, some rules do cite to specific forms, but no, there's been no push to do that.
Let me ask you, Attorney Del Campo, though, that brings up a good point. I mean, it's just referencing a number, but could somebody modify the form without anybody knowing about it? It seems like a form as approved by the chief court administrator would implicitly incorporate any modifications to the form over time as well.
If you don't have that language in there, what that basically means to the system is the owner of the form will present changes to legal services and we will approve them or not based on our discussion with the particular division. If you leave that information, if you leave that sentence in there, then all the forms that are used in this section will have to go to Judge Carroll, and I will have to formally present them, explain the changes to him, and he will have to approve them. So there is a whole different check on that.
Yeah, I mean, I don't want to overthink this, but approving a number of a form doesn't approve the content of the form. And if we have the number in there, it doesn't necessarily remain static. And nobody on this committee would know about any changes that were going to be made. So I have a slight preference to leaving it that the chief court administrator would have it, but have we solicited the input of the chief court administrator about whether he wants this authority?
No, we have not.
Why don't we do that? Why don't we do that? There may be reasons that we're not aware of about why, what the vetting process is by the chief court administrator. Is that acceptable to everybody? Okay, we'll pass this for.
Could I just add one
Judge
thing?
Farley.
And this is for Attorney O'Connor. Your memo identified a number of ways in which the proposed rule deviated from the appellate rule. And I had the understanding that the purpose of this exercise was to conform the two rules. And I'm just wondering whether, if we're passing it, whether more effort ought to be made to bring the two rules into conformance with each other, if that's a worthy use of your time.
We can certainly refer it back to court operations to see if they would like to make them match up more directly. There was mostly not so much substantive deviations. There was some, but those seem to be intentional. The lettering was a little bit different. They will use the same forms going forward. So perhaps to your point, there could be more effort put in there. We could certainly ask that question.
I mean, James and I did confer to determine that there was no conflict, but the language is slightly different in certain areas.
Right.
Does legal services support the rules committee for the appellate system as well?
No, we do not.
I think it's Jill Begeman does that. So maybe you could, since we're passing this anyway for the month, maybe you could sit down and coordinate with her as well.
Okay.
Okay.
Yes, sir.
Thank you, Judge Farley. The next item is 2021-025, proposal to amend practice book section 2-44A and rule 5.5 of the rules of professional conduct. Attorney Del Campo.
This was on, and you had referred it to the statewide bar council and the chief disciplinary council. We did do that. I wanted to put it back on just as a housekeeping measure at this point, because I'm realizing from Attorney Bowler that the statewide grievance committee is not meeting till I believe January 20th. So they will make a decision on their comments at that time. Attorney Staines, the chief disciplinary counsel, is intending to comment as well, but he will coordinate his comments with Attorney Bowler, and they will, I believe, submit a joint proposal or comments. They will joint comments for the February meeting, if that's okay with the Rules Committee.
That sounds like a plan. I'm sorry, what's the date of our next meeting?
Excuse me. It is February 7th.
Okay, they should have enough time to get the information to us.
Yes, I mean, this just overlapped with the statewide grievance committee meeting. You had instructed me to put it on this agenda, and I wasn't aware of that meeting date, so that was the issue here today.
Okay, we'll pass this until next month. Just follow up with them to make sure that gives them enough time to get the comments to us. So, Attorney Bowler, is that good with you? All right.
Yeah, I'll have something to you by the end of the month, Your Honor.
Great. Thank you very much. The next item is 2021-027, proposal to amend practice book to include uniform standard interrogatories and production requests for real property tax appeals. This is the first time on our agenda. Attorney Del Campo.
Yes, yes, it's the first time on the agenda. It was submitted by Attorney Weaver. Other than that, I would suspect you would want to send it out to your list of individuals that you want to review it. I'm not quite sure who that might be, other than perhaps some of the CBA sections.
Well, yeah. I would also, I have the unfortunate experience of doing a lot of tax appeals in my day. You might want to do the Connecticut Association of Municipal Assessors as well. That's a overarching umbrella organization for this, the assessors, and if I can remember it, there's an association of municipal attorneys. I can't remember it. Maybe it's that the Connecticut Association of Municipal Attorneys. I think it is.
Okay.
That would probably be it. In addition to the CBA has a subsection of the real estate division, I believe, that deals with tax appeals.
Okay.
Anybody can think of any other stakeholders, Judge Bellis?
Did we say Judge Abrams? I forget. I didn't hear.
No, I did not. Judge
Oh.
Abrams, yes.
There's also, excuse me, Justice McDonald, there's a presiding judge for administrative appeals, Judge Cardani, I believe, in New Britain. He might be also someone to contact as well.
Do we still have well, we used to have a tax session. That's not the same as the administrative appeals section, right? Judge Aronson used to run the tax.
Yes, my understanding though now is that the tax appeals are being done under the administrative appeals section. Yeah. So, and of course, Judge Abrams would know more, but
well, we'll leave it to Attorney Del Campo to figure that out. This is why you show up to these meetings. You learn something new about the branch every time. Okay. Thank you. Is there anything else on that item? If not, I think that's our relatively brief meeting. Is there anything else we need to address? If not, a motion to adjourn is in order.
So moved, Judge Bellis.
Is there a second?
second, Judge Avery Cobb. Whetstone.
All in favor, say aye.
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 Opposed, say no. That passes unanimously. Happy New Year, everyone.
Same
Happy
to
New
you.
Year.
Happy New Year.